As we get through the sort of first portion of the panel, I'll make sure that you all have time to engage in a conversation as well, so it doesn't feel like we're all just talking at you. So now I will go ahead and introduce our panelists. Directly to my left is Cherise Fanno Burdeen, who is the CEO of Pretrial Justice Institute, also represented in the room today, and one of the masterminds behind their 3 Days Count campaign. To her left is Andrea Woods, who is an Equal Justice Fellow at the ACLU, happens to be one of our partner organizations. And then finally, to help center this work in Connecticut, at the end of the panel, the Honorable Robert Devlin, the Connecticut Chief Administrative Judge for Criminal Matters, and importantly, the Chair of the Sentencing Commission. To begin this conversation, I want to take the national perspective and then perhaps zoom in to what's happening here in Connecticut. So, Cherise, can you set the stage for us? Thank you. Why is the American system of bail so fundamentally incapable of doing the job that it's set out to do? And what is the status of the movement to address that issue?
Great. Well, thanks certainly to the Governor's Office for including us here and for having 4 panels on this topic around pretrial, so we're delighted to participate. How many people are familiar with sort of bail reform, pretrial justice reform issues that are happening across the country, or for whom is this a brand new? So just a few of you are familiar. The rest of you, this is sort of slightly new for you. I'm sorry?
You want to know who's familiar with it, or it's new?
I'll take new. A few of you. Okay, great. I never like to tell you stuff you already know. To answer Jasmine's question, we talk about the bail system being broken sort of in 2 fundamental ways. Dual system error, if you're a geek person and want to refer to it that way, which I am as well. It's broken on both ends of the system. So as Jasmine mentioned, there's a movement in this country around fines and fees and bail and the issue of people being incarcerated due to an inability to pay. So in the pretrial justice conversation, we talk about people who are typically assigned bond amounts that they're unable to post. Most people know that if a judge sets a bond on you, typically you have to come up with 10% of that bond amount. And for the vast majority of the country, that 10% is usually a negotiated contract that you have with a bail bondsman. It is a $14 to $16 billion industry in the country. Those funds are typically being taken from communities and families who are the least able to actually make those payments. So on one hand, we have a lot of folks in jail who are in there in a pretrial status who are unable to post bond. The jail population in the country has doubled in the last 20 years, but almost 100%, actually 95% of the growth in the jail population in the last 15 years is just pretrial. And if you look at the Bureau report that came out today or yesterday, almost all of that is in rural America. And out of the 3,100 counties in the nation, 2,800 are rural. So we've seen an expansion of the jail populations in this country, and as Valerie mentioned a little while ago, you're talking about 11 million people who are cycling through jails in the country, with only a small percentage being actually sentenced to state prison. Most people are actually convicted. I knew what she meant. The rest of the folks are either sentenced to jail, sentenced to probation, or sentenced to time served. So mass incarceration is being felt at the jail level, and it's gotten a lot of attention over the last couple of years. The other system error is equally important, which is that this same money bond system that's in place today, which ends up detaining people who are otherwise sort of low or moderate risk could be released into the community, that same system is the system that's being used for the release of people we otherwise might not want released. And so a small percentage of people, it's really a needle in a haystack, who are too dangerous to be released or too unlikely to return to court. And the trouble is we've crafted a system that's designed, instead of trying to find those needles in the haystack, identify them and detain those small percentage, we have a system that's actually detaining all of the wrong people and letting, about 50% of the time, research shows, people who are otherwise qualified as sort of high risk, high danger, are using that same money bond system to effectuate their release. It is of no shock. if, as a bondswoman, I come to the jail and my choice is between someone whose bond is $100 and someone whose bond is $10,000 or $100,000, it's a much more enticing contract for me to write on someone who's high risk, on someone who has a high bond amount, especially if what I can do is finance that loan, which is really what happens with high bond amounts. Most people are financing those loans over time. So two broken pieces. Public safety is at risk when dangerous people are released, and in fact what we also now know is that public safety is compromised when low-risk people are detained pre-trial. And as Jasmine referenced, we have this campaign that Connecticut is a proud partner in, which is our 3 Days Count campaign. And the reason we called it 3 Days Count is that research shows that after only a couple of days, we rounded up to 3, but after it was 2 to 3 days, after about 3 days, low-risk people who are detained pre-trial come out about 40% more likely to commit crime or be rearrested in the future and fail to appear. So, you know, it's a similar sort of scenario to, I kind of call it a criminogenic or carcinogenic effect, right, of jail. I mean, this is an environment in which bad people don't get worse. There are no bad people, there are only people who do bad things. People who've done bad things don't get worse, but people who go in with low-level experience with the system come out worse. So the national landscape looks like this. About 10 years ago, this wouldn't have been a panel here. No one would have been talking about pretrial at all. Maybe even 5 or 6 years ago, no one was really talking about this. But under the Obama administration and under Eric Holder, Attorney General Eric Holder's leadership in the department, we helped host in 2011 a national symposium on this topic. It was the first time since Bobby Kennedy had held a conference on this. And for those of you as old as me, I wasn't alive in 1964, so I wasn't around during that conference. And here we are next year coming up on his 50th anniversary of his assassination. So we've been working on this issue and long before that. So we had this national symposium and it really brought, I think, a lot of attention to the issue, which is, everyone's trying to figure out if they were alive in 1964, I appreciate that. It brought attention to this issue as an integral component of the country turning its attention to mass incarceration or over-incarceration. Because if you really, and I love that people are interested in the reentry panel next door, but if you really, really want to have an impact in mass incarceration, you got to cut it off right at the front door. And so the front end of the system really is where we can have the biggest impact in reducing the number of people who go into our system. So how are we at the Pretrial Justice Institute and many other organizations? We work in a coalition model as well. We join anybody's coalition who wants to talk about safe, fair, and effective work out there. And we work on this issue in a number of ways. One of those ways through this coalition of partners is to try to say, okay, let's replace this. What do we want to do? Well, we would like to reduce the number of arrests. That's first and foremost. Now, you're system folks, so you might know the nuance in this. I don't actually mean decriminalization. There are other folks who work on that. In the pretrial context, we're talking about an expanded use of citations or summons. So reduce the number of people who get booked into jail, because once you get booked into jail, all these other machines have to start, and they have to all work in synchronicity. Better if you're going to be released anyway within 24 hours or less for an offense for which you could have been issued a summons or a citation, then let's do that. And let's give law enforcement the tools they need in the field to both make sure that they have a positive identification of the person before them and any other sort of things that they need to do that they were otherwise getting during the booking process. Let's try to reduce the number of arrests. The second is to replace this cash bail system. It's old, it's outdated, it doesn't even work, frankly. What we know from research is that whether or not people put up money, ransom as I call it, put up ransom in order to get out of jail pre-trial, they're just as likely to come back to court or stay arrest-free. It's not the mechanism through which they were released that has us understand how to help mitigate their situation in the community during pretrial release. It's actually the identification of people, the categorization of people. And I'll talk about that in a minute. So what are we replacing the cash bail system with? We're replacing it with something that makes a lot more sense. Judges currently today have they have a very small amount of time to deal with a lot of information about a defendant standing before them. And I like to think of a risk assessment instrument as sort of a great kind of shortcut. It really does two things. It shortcuts the process of analyzing someone's criminal history It also removes bias from, and everybody knows this, different communities, we all have this. When we exercise our discretion in making a decision, there are certain things that we inherently think are more important. And I've met plenty of judges who say, there are certain offenses that don't bother me and there are others that do. I don't like these kinds of crimes, or I don't like this kind of situation, and I'm worried about that. So I'm erring on the side of caution. And the system really does a poor job right now of helping the courts analyze all of this information before them. So risk assessment is one shortcut to that analysis. And it also helps kind of balance what's happening on Monday from Friday, from courthouse to courthouse, from county to county. We've done a number of analyses across the states, and in any given state operating under the same state law, you will have counties operating their pretrial justice systems in very, very different ways, even though they're operating from the same state statute. Bond schedules that are $10,000 for a crime here, next door county is $40,000. So there's a lot of variation from county to county in the way we're handling these things. So this also helps sort of give some level playing field to an assessment of risk. And then communities can work together to help manage that risk in ways that make sense to them and are based on their own level of risk tolerance. So reduce the number of arrests, replace the cash bail system with something that makes sense. People who are monitored or supervised in the community, that provides a level of support to those folks. It also helps protect the community. And people do better when they have some connection to the court in anticipation of their court date. That doesn't mean everyone needs home confinement or GPS. They might just need a court reminder. So there's lots of stuff we can do in replacing the cash bail system with something that makes a lot more sense. But then the other component to this, which is the third R in the 3 days count work, is to restrict detention. So as I mentioned, there's a sort of a needle in the haystack we're trying to find, and there are risk assessment tools that help us identify, first and foremost, those folks who we should just take a closer look at. And then in the preventive detention scheme, which folks with law degrees will give you a lot more information about that, about sort of the statutory requirements and the legal requirements and the best structure of putting that in place. But the sort of goal from my perspective is to make sure that we're using jails for only those people who are absolutely unmanageable in the community. And out of 100 people, that's probably 4 or 5. And sometimes that's hard for systems to get their mind around, because today, 95% of those people are getting money bonds, and maybe only 85% of them are staying detained. So if you were here this morning for the other panel with the judges, there was a conversation from the judges about what's going on in New Jersey. They've completely flipped it from almost everybody staying in jail pretrial on bonds they can't meet to almost everybody getting out. So it can be done. It's been done in DC. We have great examples from across the country. And putting in place things that can help safeguard that protection for liberty. And the last thing I'll say is this: what's happening across the country? 5 buckets, and maybe we can come back and talk about any of those buckets that seem important to you all or what you have questions about. Litigation, legislation, let's write it down. It must be important. Litigation, legislation, court rule changes, essentially field work or implementation actually within existing structures. So really just doing field work and demonstration sites, for lack of a better word. And then community engagement is the last bucket. And that's really, we've seen a great growth among public awareness on this issue and public engagement. So if you're following anything about bail on Twitter, you see forthcoming. There's a big movement to get fathers out of jail on Father's Day. There was a big movement to get mothers out of jail on Mother's Day. These are all in the sort of community bail fund or crowdsourcing bail. That's not the extent of community engagement. There's lots of other engagement around holding systems accountable, participating in county commission hearings and going to your state legislature, and participating in elections. I can't stress enough how much of local criminal justice policy is being made by people who are elected to office, and very, very too few people participate in local elections. And that's where the DAs and elected judges and county commissioners and sheriffs are making local policy and can have a big impact. So lots of work going on in those areas, and I'm happy to talk about any of those as we go through this. Thanks for my long opening statement.
It was beautiful, thank you.
You're welcome.
And there are a couple of things in there that I'll want to sort of dive back into a little bit more, and I'm sure the folks in the room will as well, but you teed Andrea up really nicely with that first bucket of litigation. That is sort of your wheelhouse, and when you look at this movement happening across the country, there's a geographic component, but as Cherise mentioned, this is also sort of an iterative process that has evolved over time. Can you sort of talk us through how the litigation efforts have evolved and where they're set to go next?
Absolutely, yes. And just to echo, thank you, Cherise, for setting that up so beautifully, and thank you for having me. I'm honored to be here and to be sharing the space with all of you. So, right, so I thought I'd flesh out just a little bit of that history that Cherise acknowledged about where we've been in the bail reform movement from the eye of the litigation perspective, where we are right now, which is a tremendously exciting place, and then where the movement may go from the litigator's perspective. So this is going pretty far back, but I thought just to set up, and for many of you in the room, this will be old news. Hopefully it's not too redundant, but we're obviously confined by the presumption of innocence. Doesn't appear anywhere in the United States Constitution, but we have the U.S. Supreme Court chiming in with that bedrock principle all the way back to 1895 and continuing to reinforce that the presumption of innocence is going to extend to every single one of the people that we're talking about when we talk about pretrial justice. And then just to slightly tweak the frame of the litigation perspective, we do see lawsuits that are challenging money bail kind of on its face, but I would just suggest that we're talking about lawsuits that challenge government trying to restrain an individual's pretrial liberty and how we weigh the individual's fundamental liberty interest with the government's interest in detaining someone or restraining their liberty. So as Cherise mentioned, way back in the 1950s and 60s, the Vera Institute was started with the Manhattan Bail Project. Bobby Kennedy was speaking out about these issues. We got a Bail Reform Act of 1966. And in the 1970s, there was a fair amount of backlash from that. We saw the war on drugs, conversations about super predators, career criminals, and that's sort of where we see the beginning of our modern version of bail being used as a way to incapacitate people out of this sense that rather than being a needle in a haystack, which I think was really apt and a great description, that everyone is a threat of this nature that needs to be treated as such during their pretrial stage of their prosecution. Then in 1975, we get a case, Gernstein versus Pugh, where the U.S. Supreme Court was considering if mere probable cause is a sufficient reason to restrain someone's pretrial liberty and detain them. They said it wasn't, which is why we get Salerno a few years later. But just to kind of indicate that at that time there was a suggestion that probable cause should be enough to just stick someone in jail until their trial, which, as many of you know, can be weeks, months, and even longer. So in the 1980s, there's this kind of that added focus on dangerousness. Dangerousness gets added to 3 state statutes as a legitimate consideration when someone's bail or conditions are being considered. And we get the Bail Reform Act of 1984, which was challenged on its face in U.S. v. Salerno, which comes out in 87. And Salerno upholds that Bail Reform Act. So that's the first, that's kind of the premier case that we're talking about when we talk about pretrial justice from the litigation perspective, and upholds the idea that it's okay for the government to detain someone preventatively as a pretrial, detainee, but only when appropriate due process conditions have been met. So someone being stuck in jail before they've been convicted implicates several of their constitutional rights, and it implicates their substantive due process right, because our liberty and our freedom is such a fundamental interest. It implicates our procedural due process rights. They need process and a lawyer and an adversarial hearing before this type of determination about their liberty can be made. And it also implicates equal protection when it becomes a wealth-based scheme. So as the court upholds the Bail Reform Act, it cites the reality that we as a society have already designated instances where we say it's okay to take someone's liberty away in the short term. That includes immigration detention, enemy combatants, it includes short-term mental health holds. And what's important, I think, when we look at this Salerno decision that's 30 years old and the systems that we have today, is how we come up short even from the promise of Salerno. The court anticipated that everyone was going to be getting this rigorous hearing that involved counsel representing your interests and needs, anticipated a legitimate protection of the Speedy Trial Act for people who were then facing pretrial detention. And as Cherise mentioned, we don't see people getting that kind of substantive and adversarial hearing, and in many cases we see them simply being jailed because they can't pay bail pursuant to a state statute or a bail schedule. So we're currently amidst a very exciting wave of litigation, and to Cherise's point about how this issue has become so much higher profile, there's been amazing litigation that I'm sure many of you have heard about from groups like the ACLU, who I work for, but Civil Rights Corps, Equal Justice Under Law, Southern Poverty Law Center, and MacArthur Justice Center, just to name a few. Really going after the money bail system on its face, and with great success. So these cases have primarily been challenging pretrial schemes where a money bail condition is what's keeping someone in jail under an equal protection argument and substantive and procedural due process argument. We've seen those cases in several rural jurisdictions, which I think is a great point that rural jurisdictions are going to need to be targeted to meaningfully change these systems. From Louisiana, Georgia, Alabama. If you haven't already seen and read the Harris County, Texas opinion, it's fantastic. It's obviously having a ripple effect throughout the country, and people are justifiably crazy excited about the Harris County decision. So look it up if you haven't yet. The ACLU has been bringing cases in New Orleans, Mississippi. Currently, we're litigating a case in Randolph County, Alabama. So that's kind of where we are. We're seeing litigation that is targeting kind of just per se detention based on inability to pay a money bail bond, which often comes up in places where bail is set by a bail schedule. Does anyone not know what a bail schedule means when I say that? Great. A wave of litigation that gets discussed a little less in these contexts, but I thought would be worth mentioning, are a handful of states that authorize the categorical denial of the right to bail for cases, charges other than capital crimes. We have a very well and long established history when we inherited bail, the concept of bail from England, that certain very serious crimes, particularly where someone might be facing a capital sentence, you could categorically say someone charged with murder isn't eligible for bail because they'd flee to save their own life, and that's a reasonable enough proxy for a flight risk or a risk of dangerousness. But a few states, 6 or 7 states, have gotten creative in terms of adding more to the list of what you can deny someone the right to bail for. And recently in Arizona, the ACLU's Immigrants' Rights Project successfully challenged a provision to say someone who's here without legal status can be denied bail because their immigration status renders them a flight risk. And that was overturned, and we recently joined counsel in a case before the Arizona Supreme Court challenging a similar scheme with respect to certain charges relating to kids under 15. So that's another place where statutes that categorically and fundamentally deny somebody the right to even have their bail considered by a judge are very vulnerable to attack bail litigation. And then just to flag that the right to counsel is really bound up in these other rights. Like Salerno tees up for us that you need a full, duped out adversarial hearing if the government's really going to justify detaining you. And to have a truly adversarial hearing means having access to counsel. So just that a lot of times, the ACLU brought a case in Orleans that dealt with pretrial justice from the vantage point of public defender waiting lists, because if you have to wait 45 or 60 days to even have counsel appointed, you have to wait 45 or 60 days before you file that motion to have your bond reconsidered. So systems that aren't adequately providing counsel can really be problematic from a pretrial lens for a variety of reasons. So just that's another place that's really ripe and rich for litigation. And then in terms of what to expect next, at the risk of stating the obvious, I think we can expect to see a lot more of these bail cases. This is an incredibly, as Jasmine and Cherise have both said, it's a bipartisan issue. It's an issue people are paying attention to. It's an issue that causes tremendous tragedy for individuals and their communities. And all of the fundamental unfairness and the constitutional rights that are implicated obviously have the nation's attention in a way. And there are all these groups that I mentioned and others that are bringing litigation and planning to bring more. So just to tee up that any wealth-based detention scheme, particularly that doesn't provide people these basic procedural protections of the speedy hearing, speedy trial right, are vulnerable to attack. And then I think that advocates should and will begin to focus a little bit on the next generation of bail reform, which would involve looking at conditions of someone's release. If we win this battle and shift to most people are being released, but then they're released on blanket pretrial conditions like drug testing or a GPS monitor, particularly if they're expected to pay for it themselves. Those will be vulnerable to attack via litigation. The Ninth Circuit has a case, U.S. v. Scott, that tees up that Fourth Amendment rights will be implicated in that context. And the Southern Center for Human Rights has also brought some private probation lawsuits, and that kind of tee up this idea that if the same person who couldn't afford their several $100 bail is being asked to pay several $100s a month for GPS testing, we're in some respects right back where we started. And also that debtors' prison work. We've seen some success there, and I think there's a tie-in in terms of fines and fees and what are you being saddled with on pretrial release. And then finally, just the other kind of expansion that I think we're seeing in the litigation world, and I hope we'll continue to see, is moving beyond challenging these basic bail schedules where it's just driving while license suspended, $750, end of conversation, into considering, vindicating the rights of people accused of more serious crimes, accused of felonies. We're litigating with Southern Poverty Law Center and Civil Rights Court, this case in Randolph County, and our client is a woman accused of a Class C felony of forging a $75 check, and obviously a person who is in the position to need to forge a $75 check can't afford her $7,500 bail. So just, stay tuned, I suppose.
Thank you. Can you lay out for us, Judge, what happened in Connecticut? What will the newest legislation do? And how does it represent sort of an evolution or outgrowth from what the Sentencing Commission did and looked at in the state with regard to bail?
Sure. Well, I want to thank Governor Malloy for inviting me to participate in this program and to be with these distinguished panelists. So in 2010, our legislature created the Sentencing Commission. And the idea was to combine all the stakeholders in the criminal justice system in one group. So we have judges, we have prosecutors, we have public defenders, we have defense counsel, police officers, corrections, parole, nonprofit groups that are involved in the criminal justice system. And we sort of work as a broad enabling statute that allows us to look at a lot of different aspects of the criminal justice system. And so Governor Malloy sent a letter to the commission asking us to take a look at pretrial release. And we did a one-year study. We created a working group to look at that. And the working group examined this in pretty good detail. I mean, we were invited to go to Washington, D.C., and some of our members of the commission went down there, spent a couple of days down there to look at their system, which is probably the gold standard in our country. We took a look at people came to us and gave us presentations. We listened to all voices. People from bail bond industry spoke with us. And out of that came some proposals that we thought would make sense in Connecticut. And Connecticut's system is pretty good. I mean, it's not, you see these systems where you have 50% of the people being held pre-trial. That is not our system. And Connecticut has, and has had for a long time, a very robust and effective pretrial services. And we have our bail commissioners. They're part of our court support services, which houses probation and family relations, and our bail commissioners. And they are, do a lot of good work. So this statute was sort of on this platform that we already have of a pretty decent pretrial services system. So what does this new statute do? Well, first off, it creates a presumption that anybody charged with a misdemeanor should not have a money bail. And so there's a carve out for domestic violence cases, but leaving domestic violence cases aside, there's this legal presumption that no money bail should be set for somebody only charged with a misdemeanor. The statute prohibits the court from setting what are called cash-only bail. So the judge might set a bail in the amount of $1,000, but order that can only be met by posting $1,000 cash money with the clerk. That is no longer permissible for misdemeanor cases. And if the judge feels that a money bail should be set in a misdemeanor case to justify that, the judge has to make a specific finding on the record that it's likely that the person will fail to appear in court, or will obstruct justice, or will endanger the safety of another person. And so it's this, and those findings have to be made at the time of arraignment. When the judge sets a bond, the judge does not know whether or not that person is going to make that bond. I mean, I might set a bond of $5,000 with an expectation that the person's probably going to make it. But I don't know that for sure. What we do know, though, is that after about 2 weeks or so, if the person hasn't made bond, they're probably not going to make bond. I mean, the number of people that make bond right away at arraignment is high, but it really trails off as you move out. So this statute requires a second look at bond. No more, if you set a bond on a misdemeanor case, no more than 14 days after that court appearance, the person comes back to court again. And the judge takes, maybe the same judge, maybe a different judge, takes a second look at that bail. Now the judge knows that the person hasn't met that bail. And now the judge knows that is this really necessary? And so again, if the judge wants to maintain that money bail, the judge should make a further finding that, look, there's a real likelihood this person is not going to come to court, or they're going to obstruct justice by, intimidating a witness or something, or they're going to endanger the safety of somebody else. And so it's a, and if that happens, then the judge will uphold that bail. I think it may well be that a certain amount of cases that bail will be changed by the judge. We're looking, in terms of this, our Sentencing Commission work, we followed a report with the General Assembly and the Governor representing our work over this one-year study. We made a proposed statute, which is largely incorporated in the statute that passed, not everything. There's some things that we thought would be good changes in our Connecticut policy that the legislature chose not to adopt, which is fine. Our initial focus is on people only charged with misdemeanors. That's what the governor asked us to look at. But this is obviously a big, much broader question than that. And the point that Cherise made, which is that if you look at the other end of the scale, the people that are out on $250,000 bonds, or the persons that are out on $300,000 bonds, and we have people like that in Connecticut. Whether the public safety sort of balance tips against public safety in circumstances like that. We haven't quite got to that part of it yet, but I think that's what we're looking at in the future. And we're looking at cases like New Jersey. New Jersey is in this sort of initial stages of turning their whole bail system upside down. They are like Connecticut, in that our Constitution provides a right to bail. So I don't have the authority not to grant somebody bail. I don't have that authority. I don't have authority to preventively detain somebody. Whether if a judge sets $1 million bond in effect of preventively detaining someone, I mean that's a fair point to make. But in terms of the options that the court has, we would have to. New Jersey changed its constitution in order to implement the system that they have. They're 6 months into it. I know there's some growing pains that they're working with, and our Sentencing Commission has open lines of communication and is sort of taking a quick, close look at how things are going there, and hopefully maybe learn from their experience. So that's a summary of our statute and how we got there.
That's great. And to stay with you for a minute, you mentioned that the Sentencing Commission sort of brought together people who maybe fall in different places on this issue. And, sometimes prosecutors, judges are criticized for the bail system, that, the system gives prosecutors an upper hand and that it's designed to give judges political cover. To what extent do you think that that is true or can be true? And what ought to be sort of the fundamental considerations of a judge when making decisions like this?
I mean, is a person going to come to court? That's number one. Is a person going to endanger the safety of another person? That's number two. So those are the two principal considerations. You want to obviously, maximize the people to come to court. You want to minimize the people that are going to fail to come to court. And you want to minimize the people that are held pretrial. Those are the sort of overarching objectives. I mean, but then you get to these secondary objectives, which are actually part of the process. And like in Connecticut, I mean, I have a chance to sort of direct, if somebody really needs some services, if they're really suffering from drug addiction, in Bridgeport we have a pilot program. On the day this person is, and Mary Heiss can verify this, on the day a person is arrested, if they are seriously drug addicted and they want treatment, we'll give them treatment that day. That day, you go into a drug treatment program, that day. So in Connecticut, we have an opportunity to sort of direct people to services if that seems to make sense. And I'll just actually, as I work with this Sentencing Commission, I've actually been privileged to work with some wonderful people here. A couple of things stand out. First off, this is mentioned, but there is zero empirical evidence, zero, that the amount of a person's bond affects their likelihood to come to court. So a person who has a $5,000 bond, or a $10,000 bond, or a $50,000 bond, you think the person who has $50,000 at stake will be more likely to come to court than someone with $10,000? There's no evidence to show that. Zero. There's no evidence to show that someone with a higher bond is less likely to commit a crime. I mean, so these sort of, and look, you're intuitive position would think that if a person has more skin in the game, they'd be more likely to kind of follow the rules. But there's just no evidence to support that. So this idea that people, we have probably today maybe 800 people in Connecticut that are being held only on misdemeanor charges, something like that. We think these reforms might be able to reach 300 of those people. That's the goal here. But this is just one step in a long ladder. Okay, but this is what we're trying to do, and I think we've sort of gained a greater understanding about it. And Alex Sarkoff was our executive director, and we're trying to put together a symposium so that the bar and the decision makers in our state can sort of raise their conscience a little bit about some of these issues.
Thank you so much. So Cherise, one of the things that a lot of decision makers are sort of tackling and thinking about as they address bail reform has been this question of risk assessment. But it has also become sort of a site of controversy. And even this morning with the panel of justices, we heard people sort of talk about, what is the deal with risk assessment? Is it fair? Is it not? Is it racially biased? Can you walk us through that and where some of the points of conflict are? Sure.
So just to piggyback on what the judge was saying, so the goals of the bail decision are what he described: maximizing release, maximizing public safety, and maximizing court appearance. But the how we do that is sort of the sticky part of all of this. So judges today go through their own process of risk assessment, right? They will they will look at the file, they will ask questions of whoever actually is at first appearance. Sometimes it's just the defendant, sometimes they're represented by counsel, and sometimes prosecutors are there. And they'll ask questions. And the person's coming into court already having had a bond set, whether it was by a bail schedule or just culturally in that court system, everybody knows the bond amount associated with that, even if it's not written down on a schedule. And so there's a risk assessment happening there. And so when we talk to courts about this shift from kind of subjective decision-making to objective decision-making, they say, oh, no, but we're already doing risk assessment. So I'll play this, I have this little game I play where I put up the 9 or 10 items that appear on most pretrial risk assessment tools. And I'll say, rank these in the order in which you believe they are the most predictive of failure to appear or rearrest. And I'll give them a few minutes to do that. And then they'll go around, I've done this with prosecutors, defense attorneys, police. I've done this with every stakeholder in this. I've done this with community groups. And the same thing happens every time I run this exercise. There isn't a single piece of paper in the room that matches another piece of paper in the room. So here are system stakeholders who, prior to this, are telling me they already do risk assessment, they know how to assess risk. And I'm not suggesting they don't, but what I'm suggesting is that the difference between what you think is important and what you think is important gets played out in courthouses every single day, and here comes the disparate impact. People of color are the bond amount set for people of color are about 4 times that of set of Caucasians with the same criminal history, same offense. And they're about 3 times less likely to be able to meet those bonds. So the current system, every time someone says, well, isn't risk assessment racist? I say, what are you doing today? What are you doing today? Today, we have a system that at that bail decision, it's having, I'm not calling anyone a racist, I'm saying they have disparate impact happening at that decision point. So, yes, the entire criminal justice, or as Alec likes to call it, criminal injustice system, not Andrea, Alec, I was referring to a colleague of ours, that entire system has its own racial disparity that starts in where we assign police officers and goes all the way through exonerations. So if you think that we, the pretrial obsessed,
if you ninjas is coming up.
I was going to say ninjas, but I didn't get it. We call ourselves the pretrial ninjas. If you think we can address and solve every racial disparity problem in the criminal justice system by fixing the bail decision, honey, if I could, I would. But I can't. So we have 2 ways of dealing with this. One, we have to try to reduce the racial disparity that's happening at that decision now. And just like when you go to the hospital and doctors have a checklist, it's because checklists standardize practice in a way that helps people not forget things and gives at least a base minimum of care. Risk assessment can help minimize or even eliminate bias in certain pieces of this decision. There are all types of safeguards that have to be put in place. Risk assessment is not some silver bullet that's going to solve every problem you have at the bail decision. You have to measure how you're applying that risk assessment. So, as Andrea was saying, if Andrea and I both score a 4 on a scale of 1 to 5, so that's how these tools work. I hope everybody understands how these tools work. They essentially have 7 or 9 items on them. As I mentioned to you, everyone will think a different one should be the most important in a rank order. Don't worry about it. Science figured that out for us. They're all weighted. It's not the number of prior convictions. It's the number of prior convictions, one or less, 2 or more. So it's not the number. It's not the gross number of prior convictions. So all of these things have weights to them. Science has figured all that out. So let's say she scores a 4 on a scale of 1 to 5, and I score a 4 on a scale of 1 to 5. We might have different presenting issues that make us risky for different reasons. But if she's white and I'm not, and she gets released on recognizance and I get released on a GPS bracelet, you can't say, well, risk assessment doesn't work. Yes, well, risk assessment actually said the same thing. You both have the same criminal history. You both had the charge with you're both a 4. But I'm going to get a different treatment if I'm a person of color. There are safeguards we need to put into the system to make sure. These risk assessments can also help us identify racial disparity. So think of this as the world's most thorough data collection project on people who are coming into the system at booking. Because there are no databases identifying anything about people in the misdemeanor system. There's no national data set on misdemeanors. And the data set on felonies is it's the worst thing you've ever seen, and it's now 15 years old. So this is a way for us to be able to also collect data on the profile of people coming into the system and being able to identify, we have problems in where we're doing certain kinds of policing, or we have problems with certain kind of charges, because most people who are charged with X are scoring this on the risk. It really does give us a lot of, but the main problem is around communication and the bridge between sort of the technical experts and the advocacy community on this space. And so we're looking forward to having those kinds of conversations and explaining, we're not like, oh, here we're from the government, we're here to help. And we understand most of you come from the system. The preponderance of people here work in systems. The people that we serve in the community have heard from us before. We know we now have a problem and we're gonna fix it for you. And we're the same people who were causing the problem to begin with. So we have a lot of communication to do around owning sort of the mistakes we've made in the bail world and being able to bring to bear solutions that will help. And I think New Jersey is a really great example. As the judge said, before this, almost everybody was getting money bond, almost nobody's getting out. Those were not middle and upper class white people in New Jersey. Those were not middle and upper class white people in New Jersey who were being incarcerated in New Jersey's jails. So the vast majority of impact of bail reform will be felt on poor people and people of color in New Jersey. So we have an obligation to implement this reform and then to microscopically manage the way the system is implementing this reform, so that we can be sure that this isn't the reform we're going to have to reform in 5 years.
Perfect, thank you. And to talk a little bit more about implementation, Andrea, you mentioned this critical notion of fundamental liberty before, and you've written a bit about the intersection of broader issues of surveillance and the pretrial system. Can you talk a little bit or share some cautionary tales and some considerations as we think about reform, how not to sort of expand the footprint of the system and of surveillance rather than shrinking it?
Sure, right. So briefly, and this is kind of going to be really abundantly clear to all of you in the room, but we live in a world where we are easily surveilled. The ACLU and my colleagues in our speech privacy and technology project valiantly fight against that world, but it is the reality, right? There's facial recognition technology, our IP addresses, our purchases, our cell phones all give away our location at any given moment. And when the government has a reason to find somebody, it's pretty good at doing it. So that reality and the fact that that's where we are, in my mind, points two directions. The first is it really fundamentally calls into question whether we can continue to justify having a bail system the way that it looks right now. And at least kind of demands that we wrestle with what continuing justifications we may have to require ransom. I like that use of the word, prior to somebody allowing to enjoy their fundamental pretrial liberty while they're presumed innocent. And then the second, which I think, I appreciate the framing of the question, Jasmine, is that it does present a real cause for concern for those of us who want to advocate for fair and effective systems. Like I mentioned before, in a surveillance society and under a surveillance regime where it may be very tempting to release people on mandatory conditions such as GPS or ankle monitors, that's going to be a terrain that we'll need to fight very hard to scale back. I could go into sort of more of the history and how our bail system really did evolve during a time where people could flee into the frontier and never be found again, but I don't know that would be the most pertinent. But just to kind of emphasize that this idea that bail is about mitigating a public safety risk really is relatively new in a long history of the concept of bail. And I believe that ship has sailed to a large extent in public opinion, but I think it's worth continuing to kind of raise that in our conversations about these issues and educating people about, it's intuitive to kind of latch on to bail and say this is something that we've had since our founders founded this country, and that's true, but it didn't look anything like this system that we have now. And particularly when we know how easy it is to track and find people if they're really going to flee, which is not that common. It challenges the rationale for demanding so much from someone up front when the vast majority of people who fail to appear do it for very uninteresting reasons, for very harmless reasons, and very few people are really going to flee, and if they tried to, much to my colleagues' chagrin, it would be pretty easy to find them. So in terms of suggestions about how to scale that back, I don't quite have the technical expertise to come up with as many concrete suggestions, but just to emphasize that before any conditions are put on someone's pretrial release, there should be evidentiary findings. There should be a real reason before anyone's subjected to a GPS or drug testing, something that's that invasive that kind of triggers more of their constitutional rights. We shouldn't be depending on user-funded systems in that arena, either through a private for-profit industry or just if somebody has to pay, a probation office or a court office, even tens of dollars a week, that can really add up over the course of the pretrial period. And I think it's just an area that reformers and advocates need to be focusing on.
And Cherise, I know you wanted to
Yeah,
add.
so I just want to add, it's funny, what I'm about to say blows people's mind, and I don't understand why they're so resistant to it, because they're willing to believe that a cucumber will scare a cat, which, if you've seen that thing on YouTube where they put the cucumber behind a cat, it scares the shit. So they're willing to believe a cucumber scares a cat, but they're not willing to believe that the vast majority of people will come back to court and stay out of trouble pending trial. So this notion that, well, Cherise, what are we going to do with all these people that you want us to now release onto the streets? Well, let me explain the risk profile of the people you're talking about. I mean, we all in the movement bemoan having at least even named this risk, right? People who are qualified as sort of low risk, the lowest risk on any scale, have a well over 95% chance of showing up for court. People who score in the moderate or mediate range have about a 75 or 80% chance of showing up for court. That's pretty high of a percent of showing up. If your kid brings home an 85 on a test, you're like high-fiving at the dinner table, right? Unless they've just ruined their straight A average. The highest risk people, about a 50-50 chance. People who like baseball, you guys are going like, woohoo, 500 at bats, Hall of Fame. So our concept of risk is really messed up at the front end of the system. It's very much informed by the back end of the system. And so most people will come back to court. Most people need no monitoring or surveillance or supervision. About 50% of people you should send home with reminders to come back to court. You should call them and remind them to come back to court, and you should leave them alone. If you overcondition low and moderate risk people, they are more likely to violate those conditions. Because why? Because you want them to come visit you at your pretrial office when they have to go to work. Because you want them to go to drug treatment when they have to take care of their kids. So low risk people need almost nothing other than a court reminder system. And I read recently something like 90% of people at booking in my home state of Maryland, 90% of people have cell phones with text capacity. So this notion that we can't text people because they're poor and they don't have phones is actually not true. And so there's a lot you can do, and as Andrea said, this notion of blanket conditions already been ruled unconstitutional, should be litigated completely. And GPS, which everyone I think also hopes is some silver bullet. Okay, we'll save a lot of money, we'll take them out of the jail, we'll put them at home or let them out on GPS. Research has shown there's only a very small number of offenses for which and charges for which GPS monitoring actually is effective. And the most promising of that research is in the DV area. So just to keep into consideration, we absolutely are with you, and it's also part of the cost-saving aspect, because we're not talking about taking an expensive jail system and replacing it with an incredibly expensive pretrial monitoring or surveillance system. And it just blows people's mind, because these are folks that yesterday they thought they should be having in jails, and today we're saying, well, just send them home. And they're going, that's like the cucumber. It scares the shit out of me. I can't do that. Okay, could you edit that part out? Okay, thanks.
Thank you for that. And it always brings back something that we talk a lot about, I think, in the movement and in our coalition, this idea that policy lives downstream of culture, and so you can change policies all day long, but But until you begin to sort of shift the carceral mindset and the idea of what our justice system does and how it ought to function, you won't get to reimagining justice or transformative change. So rather than
work the title in.
Thank you. Hashtag reimagining justice. So with that, I'm going to open it up to audience questions. We're not going to do note cards or anything like that. So feel free to raise your hand, and I will try to get everyone in the room and make sure we can have a conversation. And your hand went up really quickly.
So I'm from the Public Defender's Office. I'd like to talk a little bit more about these risk assessments. I think I understand the idea that if we go from assessing risk on a ad hoc, unsystematic way to a more systematic way, that is favorable. But what are we doing to find risk assessment tools that don't rely on factors that are dependent on pre-existing disparate impact issues? For example, we know this. Communities of color are policed differently. Children of color are arrested differently. Their criminal histories, their entire criminogenic profile is going to be different simply by virtue of where they live and what they look like. And so if we know that this is happening even with these tests that we think offer some standardization, why are we not putting in research and resources into really looking at failure to appear and what mitigation opportunities they are? Yes, maybe you have prior failures to appear, but if you're a poor person of color, living in the inner city with a couple of jobs and a couple of kids that you have to manage in order to even meet your obligations, that's a really different thing than the guy who just doesn't show up to court. So while I acknowledge that this is better, I feel like we're overselling, we're at the end of the road with these risk assessment tools, and instead we could spend resources supporting people in their efforts to come to court, making follow-up calls, giving people times to come to court that might not always be at 9 o'clock in the morning, giving people opportunities to facilitate the obstacles they have in getting to court. If we really want to maximize appearance in court, I think there are ways we can spend resources to support people better.
Absolutely. So if I ever get arrested, I want you, very impassioned, and you understand these issues. And so I'll say a couple of things. If I sold you, I wasn't trying to sell you the idea we're at the end of the road with anything. My mentor always would say, anytime anyone, compared to what, right? So we are in an iterative process of trying to say we're moving in a direction ahead. If one day we get to the point, I actually think this would be a nice place to get to. If one day we get to the point where we're through this risk assessment movement, we get to the point where we show we don't have to assess risk because there's no real risk to be assessed, and we can move beyond that into something else. And maybe we get to the place where nobody charged with a misdemeanor is detained, or we get back to only capital offenses and treason, which treason I thought wasn't going to be a crime anymore, but I think maybe now, treason, they're putting treason back on the books. I'd love to get to that place where pretrial is returned to the stage that it was when it was, in the early days. Research money is being devoted to studying the very things that you're talking about. And the way research works is it's 3,000 times slower than we need it to be, and policies are often made in the absence of good research or while we're waiting for good research. I appreciate that Connecticut has had a risk assessment, a statewide risk assessment tool for a long time, and I know it's been reevaluated over time. But advancements in the science around risk assessment are specifically focusing on trying to pull off factors from those tools that while they may contribute some small predictive capacity, the disparity that they contribute far outweighs the predictiveness of that particular item. And so when Andrea used you like my analogies, I like yours, sort of the ship sailing kind of thing. If this ship is beginning to leave the dock, then everyone who cares about this issue and wants safeguards associated with it and wants research associated with it, if you have this statewide system here in Connecticut, you're well ahead of many states who have no statewide system to be able to collect and manage data. And if you have a statewide risk tool, you're already ahead of the game in terms of collecting data. So what are we using that data for here in Connecticut, and how are we using it? And then I'm happy to give you some resources on sort of the work that's being done on racial disparity in risk assessment, but I promise you, as recently as last week, I was at a meeting with Matt Alsdorf of the Arnold Foundation, right? This sort of panacea that some people are selling of the PSA court. who again stated, we're not where we need to be, we're far better than where we were, and they have a deep commitment to continuing to work on this issue.
Andrea, I was going to say, I see you busily writing notes. Would you like to jump in?
Sure, no, and I appreciate the question, and I think it's an issue that, our organizations talk about because it is an important question in a system. I think Cherise put it beautifully, that's so riddled with racial disparities at literally every stage. How could the inputs of any tool be divorced from that racial bias? And as you pointed out, they're not. So I mean, this is something that to be fully honest, the ACLU is wrestling with pretty seriously. We have not endorsed any one tool for these exact reasons, and I think for the reason that so one thing, I think it depends on how you define fairness and neutrality, and people who know a lot more about algorithms than I do have explained this to me many times. But so I think one way to sort of pursue, and I'm grateful to hear that I know that this field is developing rapidly and that resources are being devoted, but to get a better sense, those of us who are stakeholders in this community, of what decisions do these algorithms make along the way? How can fairness from a racial equity standpoint be defined in ways other than saying that a tool is equally predictive? There's a suggestion in the academic sphere that a tool could potentially be developed, I'm not aware of one being developed, that defines fairness in terms of cross-racial error rates, in terms of who's being put in the outputs as high risk for all the reasons that you mentioned, perhaps because their risk of arrest is higher because of the community they live in, and how can a tool algorithmically correct for that? The consensus is it would probably take a hit to the predictive value of the tool, and that's something for stakeholders and jurisdictions to wrestle with. And then the last thing, I think, the compared to what is a beautiful question, both in terms of what would we compare a risk-based system to, but also what are you purporting to put a risk assessment tool into? Is it a system that uses a bail schedule, in which case people's constitutional rights are nil to begin with? Or is it a system where there's a great statute and robust hearings taking place, and then policymakers and advocates may want to examine the role that tool has and whether your jurisdiction has the ability to put in all those important safeguards that Cherise mentioned. And transparency is really important, and giving public defenders a chance to make objections and understand the tool on their client's behalf is really important.
But I think I have a little different view on this. When I was a practicing lawyer, the luck of the draw was the bail commissioner to come. I mean, if you got a bail commissioner that was sort of a real hard-nosed bail commissioner, that person was recommending serious bond. And conversely, if you got someone who was a little different, you might get the benefit of that. I mean, our risk assessment in Connecticut moved past that. I mean, it took us years to develop it. We've got this ongoing relationship with Central Connecticut State University, which we validated it more than once. It's not perfect, but I mean, it's much better than having just luck of the draw who your bail commissioner is to determine I'm sure you can't scrub out some, implicit bias from the system. I'm not naive enough to believe that. We're trying to do that. It's a risk assessment which I think is quite useful in sort of evening the playing field and hopefully creating some consistency and fairness in the same response. So I have a little different view on that.
Thank you for the inside the system perspective as well. Cherise is now moderating the Q&A as well as answering questions, which I'm here for. I appreciate it. Were you pointing to this gentleman in the suit?
I was.
Okay, perfect. Wonderful. Yes.
Is there consensus on the
You're chosen.
So I'm Richard Cho with the Council State Government's Justice Center. One of the things we're working on is a national initiative to reduce the number of people with mental illnesses in jails. And all the data we've seen is that people with mental illnesses spend twice as long as people without mental illnesses awaiting trial. And I'm wondering if you've seen, what are some of the best things that you've seen done in terms of pretrial programming or reforms with regard to specifically screening people with mental illness and considering them for, waiving bail and things like that. And I'm also, for you, Andrea, just a question about whether there's been any attempt to look at disability rights and applied to disproportionate impact on people with disabilities related to this issue.
Yeah, so that's really a tough nut to crack in a lot of jurisdictions because sometimes the only place where you can get community, where you can get behavioral health services is in the jail. And so I've seen systems, so you have to separate out, or we suggest people separate out the sort of in or out decision around pretrial release from these other confounding things that are often brought into. So one of the other things that I think is helpful about a risk tool is that issues of mental health, employment, and substance abuse are not on the Arnold Foundation tool. And so what we're advising courts through the process of no tool that we actually endorse, and there's a Virginia model is also another risk assessment tool. There's an Ohio statewide, I mean, there's a bunch of tools that you can take a look at. Not that those factors aren't important, those are factors that belong in the adversarial process where you're saying, yes, my clients are poor, but my clients are poor because they're in and out of the system because they have untreated mental health issues and they're not getting better by being in the jail, and repeated arrests don't seem to be serving the same as Zoloft might. So can we put them in a system that's more beneficial to them? Many places that have the capacity to do this, and this is a capacity issue, will have a short form screening tool, either for mental health or substance abuse or for both, that they do simultaneous. So maybe they're now no longer interviewing people for the sheer pretrial risk assessment tool, because the tool doesn't require an interview, but they're doing short form screenings, or they're doing the ODARA, so they're applying an additional risk screening for domestic violence. And they can do that during, in advance of the initial appearance hearing, so that when they go to that hearing, all of those factors can be considered. And in sort of referencing Andrea's point about sort of the individualized nature that the law requires us to have when we're determining conditions of release, those things should play a role in what the court is identifying, without running the risk of saying that your mental health is a crime, right? That now I'm somehow, I give myself permission to go into your life and tell you what treatment you should be on. So I think those short form screening tools are good, and I think they're helpful in diverting or directing people to different resources, or helping craft sort of a supportive supervision strategy for people, even if it's just referral to services. And I know CSG is doing a lot on pretrial and mental health, and so if you haven't checked out their website, they have a great website with resources specifically focused on dealing with mental health issues in the pretrial context.
It's a gap. It's a gap in the system. I mean, it really is. As a judge, you don't really have a really good answer to someone who's suffering from mental illness and comes back into the court a lot, which we see. I mean, it's just, we need to work on that more.
Just to briefly acknowledge your question about litigation and disability rights. It's a great one. And both my colleagues in our Disability Rights Project and my husband, who's an avid disability rights advocate, would kick me for not mentioning it in the litigation strategies, because the ADA and the Rehabilitation Act obviously provide incredible affirmative remedies for people who are jailed pretrial and have a disability. And as I'm sure you know, and people in the room know, like the percentage of people who are incarcerated in jails with any disability is incredibly high. I think I heard like 40% of the jail population. So I know that our Disability Rights Project and our National Prison Project, as well as our Washington affiliate, are doing some work on this, and a report was recently issued about advocating for prisoners and pretrial people in jail with disability. But I need to scroll myself up a little more.
I think we have time for one more question, and I'm going to call on you with the gray slide.
Thank you. GPS monitoring was mentioned during a couple of presentations here this afternoon, and I have kind of a Connecticut-centric question about that, so it's really directed to the judge. But when I looked at the GPS statute, it still describes it as a pilot program, and that's always had us wondering in the office, when does a pilot, I mean, at some point a pilot program has to be evaluated, and it seems to have been around for a long time as a pilot program. And so we're sort of wondering when that's going to change in Connecticut, and we're going to have some kind of shift in what the GPS statute says, instead of it being a pilot program where they're kind of tinkering with it and changing the rules of it, and we don't really know where it's going. And then, since this is a sort of next wave of bail reform, I'm just curious about when that's going to change.
Well, I think, particularly in the domestic violence context, it's been very successful.
Yes, as distinct from electronic monitoring.
Exactly. And it is expensive. And unlike other states, we don't charge people. So basically, it's on our dime. And so we've expanded it from the initial phases. I think it's really largely a matter of resources. The pilot has worked in the sense that we see this as an effective system. I think we've kind of worked the bugs out of it in terms of the technical side of things. It's really just a matter we're in a state with diminishing resources that our judicial branch took a $77 million hit. The last budget will probably take a similar hit this budget. It's just, where do you put those dollars? And so it's not, we don't think it's a good system. And we have expanded it. To make it sort of a statewide system is one which is, I think we're going to get there. But it's more about the practicalities and the sort of working out the details of the system. I think we've done that.
I think that rather than taking more audience questions, although I know that there were some reactions to the judge's comments here in the front row, I would encourage you to all speak to each other after the panel. To bring it back to this frame and this idea of reimagining justice, there's been a lot of sort of reiteration today that we are not yet at the perfect system. And so I'm going to ask the panelists for a lightning round, closing statements. If we were to have a perfect pretrial system, very quickly, what would that look like? Impossible task.
Why don't you start with that?
All right. Judge, you've been nominated. Are you ready to take on that question first? All right.
Sure. I think the best system would be one to identify the people that are truly dangerous and truly flight risks and held them and let everybody else out. That's the goal. The federal system endeavors to do that. But they detain a lot of people in federal court. I mean, like 40% of the people in federal court are detained. The District of Columbia attempts to do that, and they do it quite well. They're a system that's comparable to Connecticut, but honestly, they're a resource-rich system. I mean, they really are. New Jersey has just launched their system. The Chief Justice from New Jersey spoke this morning at a panel and was indicating that they detained 13.8% of the people arrested in New Jersey are detained. In Connecticut, in our system, which is far from perfect and hopefully will improve with this new statute, we're detaining less than 1% more. We're detaining 14.5 people in Connecticut, percentage of the people arrested. So, but that's the system, to try to get, the few people that should be detained, hold them, and everybody else gets out.
Okay, I imagine there's going to be a fair amount of overlap in the system we want, and I think the thing I'd like to add is that the miraculous system that I know I'm fighting for and many of us are fighting for would view pretrial justice from a really wide lens, including decriminalization of many things that we criminalize, including examining police practices, including diversion and widespread use of citation in lieu of arrest, so people don't even have to spend those hours and days being booked into jail with all the collateral consequences therein. And then it would look similar, other than that the ACLU opposes preventative detention. So the vast majority of people are released, where the government has a sufficient interest to seek some restrictions on that release, or to seek a de facto detention via a very high money bond, that all of those rigorous supports, a speedy hearing, well-resourced counsel, a right to appeal that bail determination, and a meaningful speedy trial protections would all be in place. Ditto.
And Cherise wins the prize for the shortest closing statement. Please join me in thanking our panelists. I want to also thank and commend the governor. I think we heard a lot today about how in many ways Connecticut is at the vanguard of these areas of reform, along with Washington, D.C., where I come from, which never gets talked about in a good way. So I'm really grateful to be on this panel today and hear about Washington, D.C. being praised rather than reviled by the nation. But Governor Malloy really did think I think, visionarily about how to address what was happening in the state and to chart a new direction, and not to be constrained by, what we all believed was the function of pretrial justice and of money bail. So thank you to the governor, and also Cherise has stickers for you. So if you'd like to become part of the pretrial ninja team, your first step is getting a sticker today. Thank you all so much.